think, well, why are they asking that question? It's purely from a government data perspective. But if you look at the second part, Terry, if we can just go on to the next slide, the second side, you'll see that when we get there, there we are, that both the attending practitioner and then subsequently the medical examiner sign the MCCD before it is then forwarded on to the registrar to allow the family to register. So you've got the GP or the doctor who's taken on the responsibility for issuing the certificate, and the medical examiner to complete that. If there is no doctor available, if the only doctor who's attended the deceased during their lifetime is unavailable for whatever reason, the medical examiner can sign this form in their own right. They would probably have a discussion with the coroner to establish that, but they would have the opportunity to review the records of the deceased through the surgery without the doctor's direct input and discussion, and it would then be decided whether the medical examiner is happy to sign that in discussion with the coroner's office, or whether it should be a case referred to the coroner. But it can be signed purely by the medical examiner. So in cases in the past where we've been chasing or waiting for doctors to come back off holiday for 3 weeks, for example, then there could be a scenario where it could actually be fast forwarded through the medical examiner taking on that responsibility to make sure that the certificates are issued in a timely fashion, hopefully. Right, thank you, Terry. If we can move on. The other thing with regards to the doctors and the medical examiners is that neither of them are actually obliged to have to see the deceased following death. Now, I find that slightly strange and in some ways concerning when we bear in mind that this all came about following the Harold Shipman scenario, and we've had 2 doctors in the past having to see the deceased, and now all of a sudden there's no obligation for anybody apart from the person who's actually verifying the death, seeing the deceased following death. And of course that person won't have had anything to do with necessarily had anything to do with the treatment of the person that's died. They may have done, but not necessarily. So there isn't an obligation for them to see the deceased. There also, as we noted earlier, there's no CREM 4 to be issued, so there is no fee payable to the doctors for issuing a CREM 4 document, and so they shouldn't be requesting any payment, and there's no payment to the ME system that is centrally funded by government, so there are no fees at all payable for the medical examiner or the doctors in future. So these key points with regards to the transition, I did send out you should have had a newsletter. Hopefully you've all been following your emails recently and reading the newsletters. We originally put out notification that the transition date was the point of the registration of the death, which was how we were led to believe that was the case from meetings with the Ministry of Justice. However, it's transpired in a slight adjustment to some of the guidance documents. In their wisdom, they only actually put the transitional process in the medical referees guidance notes, and not in the funeral director's guidance notes or the applicant's guidance notes or even the crematorium staff notes. So to actually find the appropriate section, we had to go through all the documents and find the guidance notes for the medical referees. And within that, it's essentially there were 3 scenarios. So if a person dies before the 9th of September and an MCCD is signed by the doctor before the 9th of September, then all the old documents are required to be completed. So the old cremation form 1, the CREM 4 will need to be completed, and the original green form without the necessity of the addition of form 9D being the form for the implants being stated. If a person dies before the 9th of September and an MCCD has not been signed by the doctor before the 9th of September, but instead has signed it on or after the 9th of September, then the new documentation will be required. So there'll be no CREM 4 required in that circumstance. The new CREM 1 will need to be completed, which I'll come on to in a few minutes. And the certificate will be the new green form with the attached slip, the form 9D, with regards to the implants. So in real terms, the MCCD is the important factor. There's going to be maybe a couple of days, 2 or 3 days later over the weekend, perhaps, where a death occurs prior to the 9th, particularly over the weekend, if certificates aren't then issued until Monday, which of course is the 9th, where we will then be using new forms for people that have died prior to the 9th. But essentially, obviously, anybody dying after the 9th will be the new forms regardless. The only times the old forms will be required is if the certificate is issued before Monday and the death occurred prior to Monday, of course. So unless a doctor suddenly issues a form on Sunday following a death on Sunday, which is rather unlikely to say the very least, it's going to be the new documentation required on Monday. So there may be a few transitional factors, but it's not actually going to be as bad as we first feared, because if it was purely done on the date of registration, it could have been that we had a death occur last week, for example, but they weren't able to register until next week, which we would have been on new forms already for deaths that we're dealing with currently. The only other question with regards to the coroner's scenario, again, if a person dies before the 9th of September, if an MCCD has been signed by a doctor and it's then referred to the coroner, regardless of when the coroner issues their documents, it will be on the old forms. If it's referred to the coroner today, for example, the coroner takes the case on board without there being the issuance of an MCCD, and there's an inquest after, or they issue order for burial or cremation after the 9th of September, even though the death has occurred today, then it will be the new documentation that's required. And so that's the only place you would have to make a judgment with regards to the application form being the appropriate form or otherwise, the new form or the old form. Okay. So as I think Terry had put a note on there, it's a question that you ask yourself, do we need to actually get them to sign both forms in that case, if it's a death occurring now that the coroner perhaps is involved with? It's probably sensible to do so for the few that might go through. If we're not sure when the documentation is going to be issued, it's literally only going to be over the next few days. But that's a judgment you can make. It can obviously, the forms can be filled in again, but it would mean you having to go back to your client to check that. I've just noticed as well, someone's asked in the chat how we know when the MCCD is signed. In actual fact, the medical examiner is obliged to tell the family when they've issued the MCCD to the registrar, and the registrar, they then have to register within 5 days of the issuance of the MCCD, not as it previously was within 5 days of the death.
In a second.
But the MCCD, the medical examiner will inform the family in each case when that's issued. It won't inform us, so it's quite important that you probably keep tabs on information from your clients as to when they've heard that and when they're going to register. Thank you, Terry. If we can move on. I think we'll come back to the application form because we've got another document. As I say, it is a new form, but we'll go through that because we've only got the first page of this on these slides. But Terry's going to share the rest of that a little later. So just to touch on this, one of the big questions that people have been asking about CREM Form 1 going forward is in the guidance for funeral directors. It states that the applicant has to complete the form and sign it. Now, many of you, myself included, have completed many hundreds, even thousands of application forms with a family in attendance on not on their behalf, but completing the answers that they're giving for them to then sign. Now, the guidance is debatable. It states quite clearly that you should be that the form should be completed by the applicant with the assistance of the funeral director. Now, you could argue, therefore, that you're assisting them by filling the form in. And I've had a conversation today with two of my local crematoria, and they've both agreed that the common sense passage to take would be to carry on with the same practice that we've had for many years, and so long as it's signed appropriately, signing that the information is correct. They, at the moment, unless there's a pedantic medical referee gets involved, are happy for us to carry on in the same practice as we always have done. I would recommend that you speak to your local crematoria with regards to that matter, and ensure that they're happy for that to continue to be the case, because officially the documentation, and when I've asked the question at Ministry of Justice meetings, they simply read it as it's written, without stating an advisory or anything at all. They're quite pedantic when it comes to things like that, because it's the legally written documentation that they're interested in. So, the other option, of course, is that some of the forms now can be produced electronically online. You can actually fill the document in online, and who's going to know who's actually filled that in anyway? It's then purely going by the signature and a typed document. So that's another alternative that some of you may want to explore further with regards to the completion of the Form 1. Thank you, Terry. Excuse me. This is the Form 9 Part D, which we don't have a copy of. They've not sent us a copy of the green form, but I'm advised that there is no change to the existing green certificate that's going to be issued. But this is a slip that's going to be attached and sent to the crematoria. So you can see there it simply states, was a hazardous implant placed in the body, yes or no, and then the device type, pacemaker, and has it been removed? Well, they're not going to have a clue whether it's been removed or not, invariably. So the answer to that, the likelihood is going to be no, and then you've got it signed by the GP who's issuing the doctor issuing the certificate, and the medical examiner signing that accordingly. So this would be sent to the crematoria or the burial authority, and again, as I said earlier, the burial authority have no interest in this element of the green form anyway. We have tried to emphasize the importance of funeral directors seeing this, because invariably we are the ones who are actioning the removal in most cases of transplant or of implants. So the answer we had from the General Registry Office when I asked this question was that they can only issue the green certificate and the accompanying document to the funeral director if the applicant gives permission for that to be the case. Now, again, I've spoken with my local crematoria, and they've both agreed that they will, if they receive any of these forms with notification that there is an implant, that they will inform us as soon as possible. So that's one line for you to take with regards to getting early notification of that. The other line that I've taken is we've actually had a notification from our local registrar. I don't know, are we at that slide yet, Terry, if we move on? Yeah. So we've had notification from our local registrar of a few changes with regards to the registration process. And there's a statement later in this document which that they stated that we will continue to set. I'm not sure if it's actually on this bit or on the bit that we didn't include, but it's basically stating that we'll continue to send the green certificate to funeral directors as we have done. Now, our local registrar for us has done that as a matter of course. Whether yours have in different areas around the country, again, is I have no idea, but that's something that you may want to question. Indeed, whether they will even issue electronically in some of the smaller registrars, I don't know. So it's important, I think, for you to have a conversation with local registrars if you're able and you have the contact details, just to see whether they would be happy to send them as a matter of course, or if they're happy to at least ask the question of the applicants who are there registering. If they're then happy for them to send the documents to us, we will obviously receive it in a much more timely fashion, so that we can action any removal that needs to take place, or at least endeavour to identify, because at this point it's debatable what some of the implants may be, and it's important that we're able to identify whether it's something that we can action as funeral directors, or whether we need to get back in touch with the local hospital or a certain department who may have implanted a particular medical device, and we perhaps don't have the skills or the know-how of removing that said device. So it's really important that this happens in a timely fashion, and if as funeral directors we can speed that up by having these conversations with crematoria and with registrars, I think it's really important that we do that. And we have spoken to the ICCM and the FBCA, the cremation management teams, and they've suggested that they would be happy to ask their crematoria managers across the country to forward or make funeral directors at least aware when there is any implant and what that is as soon as they receive it, rather than waiting for it to go to a medical referee who may only be looking at the papers a day or two before the cremation, by which time it's probably too late for us to make any sort of practical action without cancelling the funeral, which of course is the one thing none of us ever want to occur. So as well, a couple of other changes on the registration. Two new informant options. There's always been a list of informants and a hierarchy, if you like, of those, and many of you I'm sure will have seen that, you know, it goes from the immediate next of kin being spouse down through children, grandchildren, etc., person present at the death, that type of thing. Well, there's two new ones, one being the partner of the deceased. If they were cohabiting for any length of time, it doesn't actually give a specific length of time, but if they've been cohabiting for some period of time, they would be given equal rights as per a husband or wife, for example, if they were living as if they were married. And so that just opens up the alternative for folk who aren't married but are evidently living as if they were. The other interesting one is the personal representative that you can see there, and it's stating that a person appointed by and acting on behalf of the deceased person's family, such as solicitor, family friend, or funeral director. So from the 9th of September, they're updating their definition of a personal representative to include funeral director. So if a family for any reason can't register, either you can offer, if you're of a mind to do so, or they can ask if you would be prepared to register on their behalf for any reason. I would suggest there needs to be a good reason for that. I wouldn't be offering left, right and centre, but if it's a particular case where you feel that it would be extremely helpful for one reason or another, be that the family's going away or whatever it might be, there could be a number of reasons, that you would actually be able to be appointed to register on their behalf. Obviously, to do that, you would need all the relevant information, perhaps a little over and above what the information that you would normally have for organising the funeral. Thank you, Terry. So this just gives a basic rundown of the procedure from the verification of death through whether there's an attending practitioner or whether it's referred to the coroner, and the process that follows. Essentially, I've touched on much of that, but the big difference and the change, obviously, is that the medical examiner, their scrutiny is central to all of these elements. And as I stated earlier, ultimately they would sign in agreement with the appointed doctor with regards to what the cause is and any surrounding elements thereof. But that's the only real, I mean, the process is similar. The coroner's procedure is very similar, apart from the new documentation that's being issued at that point. So is that the last one, Terry, or do we go? Yeah. Do you want to just upload the form 1 and we just go back to that for a second, if you don't mind? There's just a few changes to form 1, which you might find helpful just to touch on. Okay. So the first question is the same as it was before, the name of the crematorium where the funeral's to take place and the name of the funeral director. There's the funeral director's telephone number and email now requested on that particular, on the new form, and the full name of the deceased person there, rather than further down the form as it was previously. You've also got the confirmation of the data protection statement that needs to be ticked. Actually, it's interesting. It's the tick box there is also for I confirm that all relevant documentation has been provided to the crematorium. Well, obviously at that point it hasn't, because you've still got it in your hands and you signed in the forms. So you can't actually say that it's been provided to the crematorium when you're still completing it. But that would have to be an advisory to the client to say that we will make sure that it goes. And if you'd like to tick that box, then all well and good. Then it's the details of the applicant. Again, as before, little more space for an email, which is helpful. The number of emails I've gone over the side of the page on in the past, but full address and postcodes obviously there, and then it goes directly into the details of the relationship. So you haven't got the piece at the bottom there of the deceased and their address at this stage. You just got the same relationship questions, and whether anybody has any issues with it being cremation or otherwise. So, and that's very similar to the previous document. The next little bit at the bottom, if we can just move down a touch, Terry, or take it up a touch, I say. Yeah, you then go on to the details of the person who's died and their address. And I think it's the date and time next, or occupation. Yeah. So this next bit, the age and the sex and everything, was at the top of the previous page before, but now they've just brought it down to be alongside the details of the deceased, which actually makes more sense. And also the date and time of death. There's been a lot of issues over the years with the question mark over somebody dying one evening and then the doctor issuing the certificate the next day, and the applicant signed to one date and the doctor signed to another date, and the medical referees have come back and said, oh, this is all wrong, you need to get your forms changed. And we say, well, this is the date that she died, and they say, well, the doctor's issued this side, you need to get one or other change. So I actually argued this point with the government quite harshly, and they came up, or I suggested this at one point, to the best of your knowledge, what was the date and time of death of the person who's died, because actually that then stops any of the questioning over whether it was before or after midnight. It's simply stating that that's to the best of the knowledge of the applicant, regardless of when the doctor states that they died. So they're not being specific on dates and times on that. It's simply to the best of your knowledge. Plus, somebody could have been found and died 3 or 4 days ago, and nobody actually knows when they died. So it was a bit of a tricky question to say categorically. So then you've got the address of the person that's died, and then we come on, I think, to the doctor's details. So you've only got one doctor to complete now. This is the medical practitioner who attended the deceased. Now, this is a badly written statement, I think, because it says, please give the name, address, email address and telephone number of the medical practitioner or practitioners who attended the deceased person. Well, that could be argued that that's a district nurse or someone who's been visiting for a number of weeks, rather than a doctor who perhaps hasn't seen somebody recently. But in real terms, that is the section really that should be the person that's going to be issuing the MCCD. It's just poorly written, I think, which can confuse a little bit. But when I asked the question, that was essentially the answer I was given, that needs to be the person that is likely to be issuing the MCCD, or the practice. If the family don't know a particular doctor, just the practice where the surgery, the surgery that the person was under, which should suffice. Then they've got the bit about the implants from the next of kin's perspective, or the applicant's perspective, and yes, no, and don't know. Of course, we all know that very often there's a yes, but we don't know what it is, and why should they? You know, it's not the next of kin or the applicants who necessarily know what sort of implant is in place. Also, it could be a solicitor or executor who had no idea whether they had something implanted or not. So you're going to get a lot of don't knows or knows on that front, where actually it could come back from registering where there is something. Previously, of course, we had the CREM 4 invariably coming through our offices, which you could check at that point, but that's not going to be the case anymore. So we would need to, if there is something clearly there, then perhaps we can action it. But the clarity should be following the registration from the forms going through the registrars. And then we've got the section regarding ashes again, which is similar. I'm trying to think if there's any changes on this. I don't think that. I think it's very similar to what's existing on the CREM 4 anyway, and the disposal of metals on there. Now, this question about disposal of metals and so on is often a question that's asked on a separate form from crematoria with their instructions, general instructions form. Sometimes they get you to get the family to sign that as well. In real terms, this should nullify the need for them to actually sign that form, because you know everything that's required on that form is in the application form now. You will probably still find crematoria, I would guess, who will still have that, use the old forms and require that to be signed. But I would argue that you could just ask families to sign this form, and that would be sufficient now. And then recovery of ashes, we tried to get this removed because it's only relevant to babies in real terms, but the government in their wisdom decided that everybody needs to tick the box to say that they might not receive any ashes following cremation, when it's only relevant to such a small number. And even then, you know, they usually get a little something back. So, and then of course the statement of truth, which if you've filled it all in, the important thing is that the full name of the applicant is there and is signed and dated accordingly. But as I said earlier, I think you need to just check with your local crematoria to make sure that they would still be happy for you to complete that document, or alternatively think of other methods and ways we can do that. Okay, I think that pretty much runs through. I hope that's at least a little bit clearer for people than we've had previously, because I know some of the webinars we've had recently has been conflicting information, There's not been some of the transitional period and so on has been issued incorrectly, from me included. I hold my hands up, but that was what we were told initially, so my apologies for that. But going forward, hopefully that's at least gives people a good clear indication of where we stand moving forward. And as I say, I'm happy to answer any questions that anybody may have or is unsure of. Please feel free to ask away. I'll open the chat up now and just see if there's anything there. Terry, have you?
Yeah, there's a few questions.
I think Donna's got a question anyway. Should we just ask Donna to ask away, Donna? If you are there, Donna, you're on mute, Donna, if you can just unmute yourself.
Can you hear me?
Can now, thank you, yes.
Hi. At what stage do we do first offices or embalm the deceased?
In essence, there's been no change as far as that's concerned. The only concern is whether there's going to be any delays in that. Now, I'm aware that different parts of the country are ready to go with this. Other areas are quite a way behind, I think, in practice. There are some where the medical examiner has been working with local surgeries constantly for the last 18 months, and they're pretty much happy to, there won't be much change for funeral directors in those areas, but there are some where there's been little uptake, shall we say, from GP surgeries who are going to be playing catch up. And won't necessarily be up to speed with a lot of the new legislation.
Sorry to interrupt. It'll delay people coming to view the deceased.
I totally get that. I totally get that, and I think it probably would need to be a conversation, perhaps with the medical examiner, if it can be done any earlier before the green cert is issued. But I certainly wouldn't go ahead regardless without having any official notification to do so.
I wouldn't anyway, there because of the
but I think it's a worry. I get that entirely. I'm a working funeral director myself, although my staff might question that sometimes. But I'm well aware of the difficulties that causes or can cause. I think for simple first offices, it shouldn't be an issue anyway. But certainly embalming,
if somebody's purging, you can't really do simple, can you?
Well, no, but I think we've had visits recently from local authorities and so on, with concerned about the care of the deceased, etc. I think we need to make a judgment on what's appropriate for care of the deceased in those circumstances, and I'm happy to stand up and be shouted against on that if anybody wanted to.
Thank you for that.
Okay.
Paul, Patrick's asked about the £27 medical referee fees.
I imagine that will be in place while ever the medical referees are there. I can't imagine them removing it until the medical referees are gone, frankly. I know the medical referees have an awful lot of concerns about this, because what are we going to be doing now, they're asking, and what's the point of us being here, and do I have to pay an extra £5,000 to renew my medical certificates to be able to carry out this practice, and if I'm only required for body parts or certain situations, and to sign off the odd document here and there without having to check what the doctors have put, in essence, which is what they were there for, checking the CREM 4 previously. We've been told that they will be in place for a transitional period of at least 6 months. At least 6 months is what we've been told, but with no end point to that. And the crematoria are thinking, well, what do we do? If the doctors don't re-register, we're going to be left without a medical referee anyway. Does that matter? Is it important that they're still there? Do we have to still put somebody in place? These are the questions that the crematoria are having, and There have been, shall we say, the answers from government have been few and far between as far as clear and clarity is concerned, because, you know, it's been a real trial. This I've been involved with government for a number of years now, and getting clear answers to simple, what we would think were simple questions, has been, it's been an absolute nightmare. But hopefully, you know, we're getting, well, we're at the point of no return now on this one, and it's just a question of how well we can manage it, and, you know, help our families and our clients through this process as easily as possible, with hopefully without too many delays. But time will tell. Yes.
Just to rattle through a few of the questions, James
Sure.
asked the question, we've noticed that there is nowhere on the MCCD with contact details for the next of kin. How will the medical examiner access this information with regards to contacting the family?
It's a good point. I've no idea. I would assume through discussion with the GP or the medical, the bereavement office at the hospital, for example, would probably have that. I mean, interestingly, my father died not too long ago, and we had a medical referee contact my brother. I've no idea how he got his number, but, you know, that was how it came about, and I think that must have been through the local surgery or the hospital. So yeah, they would get that information. It would be accessible, certainly.
Jeff's asked the question, if I understand correctly, paramedic or palliative care nurse verifying end of life will pass on information to the GP. Is this correct?
That's what should happen.
Yeah.
Well, that's what should happen, or on their behalf through the 111 system.
Yeah.
They should inform the surgery, so we shouldn't have to. My concern is that I know that I've had many occasions where I've been waiting for families have come in and said, oh, we've not heard anything from the surgery. You phone them up and they didn't even know they'd died 2 or 3 days later. So my recommendation always is, and my office certainly would phone the surgery the next morning and just make sure they're aware. It's a phone call. You know.
Yeah. And the GP surgery sends the information to the medical examiner. That's the trigger, isn't it?
That's correct.
Yeah,
That's
Sam
correct.
was asking that question.
Yeah.
Oh, Natalie asked a lovely question. How long will it take the medical examiner to complete the MCCD?
To complete the MCCD, it depends whether you're talking about signing it. It depends how long it takes him to sign it. But the actual, it's more the liaison and the inquiries that he has to make, as far as how long it's going to take. I have come across cases already where some medical examiners are only working part-time, sort of 3 days a week rather than 5 days a week. So there may be odd days where things don't get dealt with in hospitals or in the community, potentially, where they perhaps haven't got the full quota of medical examiners currently in place, or medical examiner officers, because there are medical examiner officers working for the medical examiners who can do a lot of the donkey work for them as far as the liaison with surgeries, etc., is concerned, to access documentation. Some of the GP practices, there's concerns over their capabilities with regards to the electronic transition to the medical examiners and so on, and subsequently on to the registrars, and whether that may cause delays. So there's going to be a number of teething issues, I think. I think in practice, it's a conversation with the doctor, a conversation potentially with the coroner, but in most cases then with the family, before then deciding that they're happy to go ahead and issue the certificate. So,
Okay.
you know, how long's a conversation? How long's a piece of string?
Cara asks how to define an enduring relationship if they are not living together but partners.
Good question.
So
That's a new statement that's been put out today. As far as I'm concerned, it's new to me, and there didn't appear to be anything that stated categorically what that was. I would have to look into that, car and see if there is any guidance on that from the GRO. But it's a similar thing to the DHS, the applications for social support, the funeral payment, and whether they're partners and how you define that. And they've never been that clear on that either. So it's a tricky one. I think it's probably, as much as anything, a case of if the rest of the family are happy for that to be the case, then it would probably be accepted as being the case. But yeah, ultimately it'd be down to the registrar to decide.
Okay. Cynthia is asking, is it worth getting something in writing from the family if we're asked to register on their behalf?
Yeah, absolutely. I would think that would probably be a requirement. Certainly sensible to protect yourselves from anything going forward. It could be. I think you noted earlier, Terry, the possibility of if we're filling an application form in, a note from them saying that they're happy for you to actually complete the application form, answering their, completing their answers to your questions might not. That's another way potentially of covering the issues with regards to the completion of Form 1 as well. But certainly, yeah, if you're expected to register, I would think they would need written notification that you've been given permission to do so. You can't just turn up at the registrar and go ahead, I wouldn't think.
Question about how do we as funeral directors inform the crematorium that devices have been removed? We used to the details on Form 4 and sign that.
Well, the doctors had it on Form 4. It is on Form 1, of course, the application form, but you're only asking the question at that time, really. What we have done locally, and will probably have to be the case, would maybe be an electronic notification, just maybe on headed paper or something, signed by whoever's removed the device to the crematorium, just a simple note saying, a pacemaker has been removed or from Mr. X, Y, or Z.
Okay. Question from Adrian: who will notify the hospital mortuaries when a deceased is cleared to be collected by the FD, as they will no longer receive crem papers?
No, but they would, if it's a hospital with a bereavement office, which most of them would have, they would be aware of when the MCCD has been issued. And so the mortuary, I would imagine, would be informed in that same vein, and there just wouldn't be a crem for to collect or deal with on that front.
Okay. We've had a number of inquiries about this is being recorded, and we will share this recording with our members. Also to say, SAIF's Education Day on Saturday, the 5th of October in Leicester, we have invited a medical examiner to come and be our keynote speaker, and I put a link in with the booking form should you wish to join us there.
And I won't be there to answer any questions, so thank you very much.
Okay. Also, we've been asked about medical examiners. There is a website with the regional medical examiners. I'm going to try and find the link and put it in the chat box.
Yeah, and I think that would be really helpful, actually, for members to touch base with medical examiners in their areas, just as far as, guidance. I know a number of them have done webinars and so on in different parts of the country, but it's important that you have a contact as well if there are any issues. And because the medical examiner really is the central cog in this wheel now, you've got the GPs, but they can't do anything without the medical examiner. The medical examiner then decides whether something's referred to the coroner or not. But if there are any delays or any questions or concerns, for you to have the medical examiner's office's number contact and liaise with, I think would be really sensible and appropriate for you to have. And I'm sure they'll be delighted with all the inquiries they'll be getting over the next few weeks.
Okay. Anything else that you want to raise, Paul?
I don't think so. I mean, I hope that at least has made it a bit clearer for everybody today with regards to the simple procedure, just to get us over the barrier of next Monday, essentially. And then going forward, I think it will be a learning process for all of us, but particularly a lot of the GP surgeries around the country, I think, are the ones who are very often a bit behind, to say the least, in understanding or at least accepting this process. Other than that, I just seen somebody just put a question in the chat about faith deaths. We are assured, interestingly, that faith deaths, as is currently the case, will be dealt with as a matter of urgency and will be dealt with in the same way and just as quickly. So that's what we're advised is going to be the case. Again, practice will tell on that front. The only other thing that was a concern that Joe raised, Terry, in Scotland, there has been some debate over what's the situation. Is paperwork changing when we're sending people abroad, or particularly up to Scotland or Northern Ireland out of England and Wales, of course, which happens every single day. And Joe raised a concern, Joe Murren, the Scottish Government representative of SAIF, raised a concern with regards to the paperwork changing, because there's not going to be a Crem 4 going forward, and the crematoria up there were expecting that with any bodies that came up from south of the border. And we haven't really had a definitive answer to that as yet. No. Simply that, you know, there will be still an out of England form, but that would essentially be the only thing, because the registrar wouldn't be obliged to register the death. So it's, you know, just a conversation again from doctor to ME, but then we'd have to advise them that it's going abroad and advise the coroner accordingly. But if and when we get any clarity on that question, again, we will obviously make sure members are aware of the situation there.
Great. Okay, I've put the medical examiner's list in the chat. I think we're good to wrap this up, and thank you so much for being with us. We've got a final question. Paul, can you see that? Whoops. Will the bereavement offices in hospitals still require a copy of the registrar's certificate to allow us to bring the deceased into our care?
Sorry, can you repeat that one?
Will the bereavement offices in hospitals still require a copy of the registrar's certificate to allow us to bring the deceased into our care?
That will be dependent on each hospital, really, because they don't all require that currently. Many will have a release form issued to the funeral director rather than them requiring the green certificate. So it will be down to each hospital, I think, with regards to what their requirements are. Hopefully there won't be too long a delays. There was a question also on here, if we can confirm if it's the medical examiner who issues the MCCD to the registrar or the practitioner. The medical examiner is the one who signs it secondarily, and my understanding is that it would be the medical examiner who forwards this and then informs the family that they have done so. So that should happen all through. And this is another reason why it would be helpful to have the medical examiner's contact details and information should there be any delays or issues, because we all know what fun it is trying to get hold of doctors' surgeries at the best of times, even to make an appointment for ourselves, never mind just trying to get through to them. But many have email addresses and the like that we can send, and again, the list of medical examiners. Have you put that on, Terry?
I have, yeah.
Yeah. So, you know, that would be helpful to for you to take note of your local medical examiner's details and, you know, touch base with them with any concerns or questions that you may have going forward.
Great. And it'd be good to get your feedback. Malcolm Flanders suggested a review, perhaps in 3 months. I'm sure the Ministry of Justice will love us for that.
I'm sure they would.
Great. I think Jane has one.
You're on
Jane,
mute, Jane.
Okay. I think that was a goodbye hand.
Oh, was it?
Let's wrap this up.
Okay. Well, thank you for your time, everybody. And hopefully, as I say, that was helpful. If anybody has any further questions, then, you know, do come back to us, and I'm sure we'll do our utmost to help if necessary. And I wish you all a smooth and gentle passage through the 9th of September. Let's hope it does go as smoothly as we hope it will, but no guarantees. I see some rocky seas ahead.
Thank you, Paul. Much appreciated.
Okay.
Thank you.
My pleasure.
Bye-bye.
Bye-bye, everyone.